Oh no, is your loved one being detained in immigration custody? I'm so sorry that you and your family are in this very unfortunate situation. I wish we were talking because I wish you were listening to me because you were coming here for better news. But now I understand that the entire family is desperate to get him released, right? So because I handle immigration detained cases regularly, I am skilled at presenting strong evidence to increase the chances of getting the person released from immigration custody. The most important thing is that I am results oriented. Yes, results oriented. And that means that everything I do is designed to get the result that we want. Now, of course, many experienced lawyers will tell you that there is no guarantee that the immigration judge will set bond. I say that too. I will not pretend that there's some magic wand to be waved, but because I am results oriented, we increase the chances of getting the immigration judge to set bond. And to persuade the immigration judge to set bond, my team prepares and files a bond evidence packet to which is the judge's first impression. And very often the immigration judge has already decided to set bond because based on the packet itself. So the immigration judge looks for two things. Is the individual a flight risk? That is, if he is released from immigration custody, will he return to the immigration court for his case or his next hearing, or will he run away? And the second thing is the individual a danger to the community? So if he was charged with committing a crime, will he repeat these actions and harm others if he is released? So the immigration judge also wants to know whether the person qualifies for any kind of immigration relief. That is, can the person win his case in immigration court? If the person is ineligible for any relief, that is not eligible for any relief, the judge usually denies bond or may set a very high bond. I will tell you that when we speak, because that's one of the things I have to analyze. Now, the immigration judge also asks about prior immigration history. Whether the person has legal status. Did he enter the United States without authorization? Has the person been previously deported? Has the person been previously deported and illegally re-entered the United States? These are all things that affect bond or no bond. Then the immigration judge asks whether the person has ties to the community. How long has the person lived in the US? Does the person have family members in the US? What is their status? Are they US citizens or lawful permanent residents? Does he have a job? Does he own any property in the United States? So we include proof of the US citizens and resident family members, their medical records, school records for children, photographs, employment history, income tax returns. We also ask for letters of support from the family members and colleagues and employers, and we guide those, we review those letters and recommend changes if the letters all sound exactly alike. So please do not spend your money going to get someone to write 5 letters for you that are all identical. Don't waste your money. We'll do that for you. And so the most important thing that we include is detailed declarations from family members explaining whatever we want to tell the judge. And now writing declarations is one of my creative skills and the secret sauce to getting results. And I want to tell you a quick story about how I won an asylum case. And it's the same skills that are transferable to any area of litigation. I had an asylum case where my client had a very sympathetic case, and she was a victim of rape, and there was trauma involved. It was very delicate. We went to court, and the immigration judge, after I had presented the basic evidence of my client's name, address, phone number, family members, and the basic pedigree information, I said to my client, Miss Jane Doe, I'm going to now ask you some questions about the incident for which we are here before the court. And the judge stopped me and said, Ms. Kundanmal, That's enough. Thank you. I find her credible. I'm going to grant asylum. I was shocked. I was happily shocked because I couldn't believe that I did not have to put on a single bit of verbal evidence to get the case granted. So the case, we were there for about a half an hour, and as I got up from my table, the judge said to me, "Ms. Kundenmal, this is the best documented case I have seen." Now, I was flabbergasted to hear that. I was proud and thrilled and excited to hear that, but I couldn't understand why a judge of 11 years on the bench was able to say to me, or said to me, that this is the best documented case he has seen. And he said that to me 2 times after we left, on my way out. Now, I've thought about that a lot and wondered why the judge said that to me. And I will ask him one day, because he's still on the bench, but because of COVID, we haven't gone back that much and I haven't seen him. I thought about what prompted him to end the asylum hearing so fast and not take any real evidence, any substantive evidence, as we call it, and grant asylum to my client. And I realized that it was in the depth of my declaration. So I know for sure that my declarations are the secret sauce to my winning cases. Now, bond is a different set of factors because the crimes really affect the ability to get bond. But nonetheless, I will do my best and present my secret sauce declarations in your case too. So if I can help you, please let me know. And hopefully this will not be the only time you are talking to me. Thank you.